But I want to go to Misty Marris for a second here, because Misty, Laura said you really can't overstate how shocking this is. Walk us through it from the legal perspective here, because you have to think that when we hear from the lead prosecutor, he's going to be furious with this. This is not what prosecutors want to see.
Definitely not. And again, it's so rare because appellate courts do not want to overturn jury verdicts. They have a whole lot of deference and respect for them. But here what the court looked at was whether or not Becky Hill actually engaged in misconduct. And if she did it matter? And that was the decision the court had to make. If she engaged in misconduct, did that actually impact the jury's ultimate determination? And I think what you're going to hear from prosecutors is that the reason that this case was overturned had nothing to do with the way that they handled the case. It had nothing to do with the weight of the evidence and how powerful their case was. It was because of impropriety of someone not involved with the legal team, of a third party outside of all of this. And so I think you're going to hear a really, really stark statement that they're going to move forward with a second prosecution.
So, let's talk about what that would look like, because what does another trial look like here on a case that, like, I just can't imagine that you're in South Carolina and you hadn't heard of the Alex Murdaugh, murder trial. That's not the bar for having somebody sit on the jury, but is it going to be difficult to try to seat a jury that doesn't already have a predisposed notion of this when that guilty verdict was so, it was everywhere. Everybody knew about it.
Everybody knew about it. And Hallie, think about what's out there. It was a televised trial. Murdaugh actually testified.
I'm going to stop you here because the South Carolina Attorney General taking the microphone. We're going to listen in.
Okay, we ready? All right. Good afternoon. Thank you all for being here this late in the day. We're sorry we couldn't do this earlier. Obviously, it's been a very busy day. For those of you who don't know, I'm Alan Wilson. I'm the Attorney General for South Carolina. I have standing with me Creighton Waters, who's the Chief Prosecutor in the state grand jury and the Chief Prosecutor on the Alex Murdaugh trial team. Go ahead just to kind of sum and tee up everything. Today, the South Carolina Supreme Court ruled in a 5-0 decision to reverse the murder convictions of Alex Murdaugh. Ruled in a 5-0 decision to reverse the murder convictions for Alex Murdaugh for the June 2021 murder of Maggie and Paul Murdaugh. The court based its decision on the conduct of then Colleton County Clerk of Court Rebecca Hill. As you know, this conduct involved her interactions with the jury at that time. As the court said in the order, this was conduct unknown to the state and other individuals. My office's position has always been that the conduct, while inappropriate and should never be condoned, was ultimately harmless as it related to prejudicing Alex Murdaugh's right to a fair trial. The Supreme Court obviously disagreed in its conclusion. While we strongly disagree with the Supreme Court, we respect this decision because that's how the process is supposed to be played out. So now we must look to the future. What does this decision mean going forward for this office? First, Alex Murdaugh is currently serving a 27-year sentence for the financial crimes that he has admitted to in a guilty plea that we secured against him, and he has also waived his appeals for those financial charges. Additionally, he pled guilty to federal charges about 5 months after he pled to the state financial charges. He received a concurrent 40-year sentence. So Alex Murdaugh for several. Our office is reviewing the legal team and our staff. We're evaluating what our strategy will be. As of right now, the state has 15 days to ask the state Supreme Court to reconsider its decision. We have 90 days to appeal to the. However, it's currently my intention to seek a speedy retrial. Obviously, I always say that this current decision recognize defendants the presumption of innocence unless and until they are proven guilty in a court of law, and Mr. Murdaugh will enjoy that presumption at this time. Are there any questions?
Mr. Attorney General, your opponents in the governor's race are jumping on this, saying your office bungled the case. I know the court's decision pointed the finger at Becky Hill, but are you worried that this is going to affect your campaign for governor and will look poorly upon your records?
No, not at all. Obviously, the court has been very clear. People who have never actually been a prosecutor, been in law enforcement, step foot in the court of law, the hand of a victim as they got a job gone through this process, make all the political
Just want to
haymakers they
note
want
here
out
that
of
if
this,
you're
but at the end
having
of the
trouble
day,
hearing his microphone there from Alan Wilson, that's not you. That's an issue from the room. The team there is working on getting that fixed. But significantly here, you've heard the South Carolina AG say they will seek a speedy retrial of Alex Murdaugh. You see the lead prosecutor on the Murdaugh case there as well. This is a significant moment here because it does mean that they are barreling toward putting Alex Murdaugh back on the stand. Again, he's not going to walk free before then. He's serving time separately for all of these financial crimes he's pleaded guilty to. But an interesting moment here in South Carolina. Let's see if they've worked out that audio. Oops, I'm being told it is still not great. We're going to work on that. And while we do it, let me bring back in Misty Marris here. Now that we know, listen, this retrial is going to move forward, Misty, I want you to pick up on that thread of what that looks like, how they seat a jury, how long that will take, and what a timeline is.
Yeah, so they said they're going to seek a speedy trial. So that could mean we'd be on a fast track. Now, to seat a jury, Hallie, this is going to be tough because think about how much attention has been on this case. Not only did we have a trial that was televised, we had Murdaugh testify at that trial, countless documentaries, series about this particular case. You're not going to find people who don't know about the case. That would be virtually impossible in South Carolina and across the country. So the question is, can you seat jurors who are going to go in without a preconceived notion, look at the evidence and make a determination? And it will be done in the same way we see in other high-profile cases. You're going to see jury questionnaires that are extensive, and you're going to see a significant questioning during voir dire.
We're told the audio is better now. The team's got that fixed. Let's listen back in.
Charges with conduct unrelated to this case. I'm not going to speculate on anything else at this time. Yes, sir.
Did this ruling come as a surprise, and what can you tell to the people of South Carolina who might be worried about the cost of a second trial?
Well, first off, our office has always maintained, and we've never disputed, that the conduct Ms. Hill engaged in was inappropriate. We have always maintained that the conduct was harmless error. Obviously, for those of you who watched the post-trial hearings, for those of you who saw everything unfold in real time, there were many, many, many witnesses who testified that this, I think 11 of the jurors testified in open court during that post-trial hearing that they did not believe that this affected their decision. We believe that it was harmless error, and so obviously when the court came to a different conclusion, it was obviously disappointing to me personally, and it was disappointing to Creighton. It was disappointing to other members of our team.
And as far as the cost of a second trial, for those who might be concerned about the legal costs incurred going forward with this, considering he is behind bars for several decades.
Here's the thing. When people are murdered, okay, when victims are murdered, they have a right to have their case adjudicated in court even though they're not currently here. Their family members who they left behind have a right, for those who want to see justice meted out, they have a right to that. So we're not going to let that be a factor in our decision to move forward. Seeking justice is the role of this office. Enforcing and defending the rule of law is the job of this office. It is the job of the men and women of this office, and that is what we have always held to.
Do you plan to prosecute the case any differently this time?
As I said a moment ago, Mr. Waters and I have been in consultation all day. He's been talking with members of our team here in the State Grand Jury Prosecution Division. We don't want to comment publicly on what our legal strategy would be moving forward. Obviously, there will be very little surprises to the general public as this case gets retried again. But obviously, we have a roadmap the Supreme Court has given us based on what they have put forward in their order. But again, I don't want to talk too much openly about what our legal strategy would be because we haven't gotten there yet.
Was there ever any consideration of possibly taking this case up to the Supreme Court? You said you had a window to possibly get that done. We're
still in that window for 3 more months. So obviously it is something that we are contemplating all of our legal options, and we're exploring everything. This just happened today. So making a firm decision one way or the other on what we want to do on our right to appeal are things that we're going to be talking about in the hours and days to come, and we will be making those decisions. Regardless of that, it is my current intention to seek a speedy retrial of this case.
With the documentaries and the different podcasts that are already out, do you think that will taint anything in the case or the retrial?
I mean, look, you always are concerned about the exposure a high-profile case gets, and that is always something you're concerned about. But obviously, the process is designed and built to kind of cull that out. And obviously, I trust the process and the system to help us get back to a court of law where we can get this information back to a jury.
One more question.
How quickly do you expect you could be back to trial with this?
My intention, and we've talked about this, it's aspirational, but we would like to try to get back before the end of the calendar year.
You might not be Attorney General by that point.
Irrelevant. It doesn't matter who the Attorney General is. The Office of the Attorney General will still be here. Would I like to be involved in this case like I was the first time? Absolutely. But like I said, the men and women, many of the men and women who were on that original trial team are still in this office. Some have obviously moved on to other opportunities, but most are still here. This office is still going to be here long after Alan Wilson leaves it. So the decision on whether or not to pursue this case is not going to be built on who the next occupant of my office is. It's going to be built on should we seek justice or not, and we're going to seek justice. I'll take another question or two, then we have to run.
I guess, Attorney General, there's been calls for reform of the system. You yourself have called for judicial reform. Given that the finger's been pointed at the clerk, are there any reforms you think should happen for clerks within the judicial system?
Look, the system worked when it came to the former clerk of Colleton County. Obviously, after the fact, unknown to us, as the court said in its order, her conduct was obviously made known. That was handled by the system. Other conduct that she engaged in, which was discovered long after the trial concluded, that ultimately led to her conviction for misconduct in office, was handled by another solicitor's office that I signed in that case, and that was handled appropriately, and she was convicted in a court of law. So the system addressed that individual.
And I know you're not going to speak about your strategy, but do you think the evidence that they pointed out that you spent too much time on the financial woes of Murdaugh, do you think that's going to have an impact on your trial going forward?
I mean, look, we have the benefit of hindsight now. We believe, and the court did say in its order that the evidence that we got in was permissible. They obviously provided us some guardrails to go back on remand to the original trial court where it will be tried, and they gave some guidelines and some guidance that we will obviously evaluate and use as a guide in presenting the next case. I'm happy, and Creighton, if you want to take a moment, I'm happy to let you address that issue as well.
Yeah, I mean, absolutely. We, of course, were, aggressive about that evidence, but as you recall, we filed multiple pretrial briefs. We laid out our theory of the case. We put all that evidence on the table, and ultimately Judge Newman heard it all and agreed that it was permissible. But this is part of the process. The Supreme Court multiple times in the order said that this was viable evidence of motive, but ultimately gave us some guidance about the extent. That's how it works. You don't hit a home run if you're afraid to strike out. And so as a prosecutor, you have to deal with double jeopardy. We had a viable reason for putting in this evidence, and so we did so. Ultimately, the court, as the AG said, ruled on Becky Hill, and then they said, while we're at it, hey, this is permissible evidence, but let's put some guardrails in place. That's just part of the process. They also, though, multiple times in the order talked about I think they called it superbly competent and professional presentation by both the state and the defense. So these things are not 2 + 2 = 4, and we did our job. We still believe that the case should have been affirmed, but we recognize the court's reversal, and now we're going to go do it again. That's the plan.
Mr. Waters, thinking back to January, in which arguments were brought before the state Supreme Court, was it a difficult or untenuous position to have to, in some ways, talk about Becky Hill and basically, in some ways, make sure that, to say it no other way, to kind of defend her in that hearing?
Well, again, whenever you try a case and you, as a prosecutor, like I mentioned, with double jeopardy, you have to, within your interpretation of the rules, be aggressive. And so we were expecting that. The one thing you don't expect is to ultimately have to address these issues with the clerk. As we presented to the court, and as the AG just said, we thought that Justice Toll got it right, that ultimately there was no effect on this verdict after 6 weeks of trial and all the evidence that was presented. Supreme Court saw it differently, and that's their prerogative to do so. so. So certainly that was not an issue that we were hoping for and expecting, and unfortunately that was the one where the Supreme Court hung its hat. But again, that's part of the process. You dust yourself off, you get back up, you take a fresh look at it, and then you go do your job. And that's what we plan to do.
I want to close.
You have been listening to top prosecutors in South Carolina talk about their next moves there after Alex Murdaugh's double murder conviction has been tossed by the state Supreme Court there. I want to bring in Laura Jarrett and Misty Marris. So, Laura, let me start with you here. It's interesting. You know, they noted that they didn't love what Becky Hill, the court clerk, did either, right? They didn't think that her conduct was super great, to put it colloquially, but they thought that it was essentially harmless, right? Explain why the state Supreme Court disagreed, and not just disagreed, but disagreed to the point where they overturned this jury conviction.
Yeah, they want to hold Becky Hill's conduct at arm's length because they know that it's bad, and they just now have a Supreme Court decision calling it disgraceful. So they have to keep that at arm's length. But oftentimes you see this where essentially the court says, we know something bad happened, but it's, quote, harmless error. In other words, there was so much other evidence suggesting that he was guilty that even if she did do this, even if she said, hey, take a close look at him on the stand, they heard enough other evidence that would have been persuasive. And we heard this from the jurors today. There was enough overwhelming evidence of his guilt that she didn't need to engage in a pressure campaign because they were going to find him guilty anyway. The court today, the high court today, saying no dice on that what she did was so grave, it essentially infected the whole process, Hallie, and you can't really disentangle her pressure campaign from what other evidence they were hearing. And even if she only told some jurors, they were then in deliberations with all the other jurors. And so the court just unwilling. And by the way, this is a unanimous decision. It's not as if they were all split on this. They essentially saying they just couldn't disentangle what she had done. It had so badly tainted the process that it's essentially irretrievable. So that's why they have to do it all over again.
You also heard Misty, the Attorney General for the state there, say that they are planning to pursue what he called a speedy retrial by the end of the calendar year, which is like, you know, probably 3 minutes in like legal timelines here, but that they would also look at their other legal options. Does that mean, is there any possibility that they could appeal this up to the Supreme Court here in Washington, or because it's a state case? How does that work?
Yeah, so Hallie, they have two options when it comes to an appeal. One is asking for the court to review its own decision and say, hey, court, we think you got this wrong. This is the South Carolina Supreme Court. Look at this again and make their arguments there. Unlikely to succeed. I think something Laura brought up about the arguments that were presented before the Supreme Court previously. You know, we have a unanimous decision. They're unlikely to find themselves in the wrong. But because this is a final determination by the highest level state court involving what could be a federal question, your right to a fair trial, it could potentially go to the Supreme Court for review.
If it doesn't, if it moves forward with a retrial, Laura, you heard the AG say that there would be maybe very few surprises, I think he put it, over the course of a trial to an audience that might be watching here, or to the jurors there. There are some things that they might have to tweak, and you heard Creighton Waters talk about that right at the end, right? Like how heavy they went in on the financial crimes piece.
Well, because you see some language in this decision, even though it wasn't sort of the bulk of the decision, which was about Becky Hill here, they have some language suggesting you went too far on the financial crimes thing. Remember, that was not what he was charged with here. He's already pled guilty to that. It's a separate issue. But prosecutors wanted to bring it in this trial to prove motive, to say, look, they were about to blow the lid off of all his financial problems, and essentially prosecutors said that's why he killed his wife and son. Now, he disputed that, and that was obviously not, you know, the defense's contention. But the court took care to say here, they just harped on too much of it, and some of it could come in, but they just said if they do this again, they need to be far more narrowly tailored in how much they let in. And so that is going to affect their strategy here. And I asked the AG before he went up for that presser today, like, how are you going to have to change things? And would you be open to a plea for him? Because remember, he has pled guilty to those financial crimes. And I said, would you be open to a plea? He would not rule that out, Hallie.
Would it behoove Alex Murdaugh, Misty, to try to take a plea here?
I don't know if it would be a bad idea. I mean, listen, he's maintained his innocence for the entirety of the trial. Remember, he took the stand and proclaimed his innocence and has maintained that position throughout. So if it's principle, then of course no plea. But if it really relates to the practicality, he's already serving multiple sentences behind bars. So going through another trial would certainly be a battle for him.
Misty Marris, Laura Jarrett, thank you both so much for being with us, walking us through all of it as we've been watching this live rolling coverage here. Appreciate you both very much.